Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about the lack of evidence or US Captain Richard Arson case. A military judge found seaman recruit Ryan Mays not guilty on September 30 on setting fire to a 1.2 billion Navy ship. Mays, 21, had stood trial on charges of aggravated arson and willfully hazarding a vessel for the 4-day blast that destroyed the USS Bonhomme Richard, an amphibious assault ship in 2020. The acquittal marks the end 2-year ordeal for Mays, who spent 55 days in the brig after he was arrested. I can't get everything. I have lost back, but today is the start of my new life, Mays told ProPublica in a statement. I am grateful that the military judge saw me for who I am. An innocent man who wanted to serve his country. The fire was traumatic for me and a lot of other sailors. The court-martial is an edit from Lawyer of Trauma. On July 12, 2020, the Bonhomme Richard was moored at a San Diego Navy base and undergoing a major overhaul. That morning, an area of the ship known as the Lower 5 caught fire and the blaze quickly spread throughout the vessel. The warship was lost and had to be decommissioned. A ProPublica investigation into Mays' case found there was little to connect him to the fire. There was no physical evidence that Mays or anyone purposefully set the fire. The Navy had one witness who placed Mays at the scene shortly before the fire, but whose story changed over time. The criminal investigation into Mays also stood at odds with another Navy inquiry into the fire, which found that 34 people, including 5 admirals, either directly led to the loss of the ship or contributed to it. That investigation uncovered a litany of failures that put the ship at risk for a catastrophic fire, including poor training, insufficient oversight, and dangerous storage of the hazardous material. Additionally, 87% of the ship's fire stations were out of order. The Navy continued to pursue Mays even after a military judge recommended this year that the case be dropped for lack of evidence after a probable cause hearing. In closing remarks, Mays' lead defense attorney, Lieutenant Commodore Jordi Torres, said the investigation was a live-fire exercise in the dangers of confirmation bias. He said investigators and then the prosecution discounted any evidence that did not fit the narrative of Mays as the arsonist. The lead prosecutor in the case, Captain Jason Jones, told the judge, "You're allowed to use invariance of circumstantial evidence in making of determination of arson." Jones said criminal cases are like puzzles, and even when there is a missing pieces, the picture is still clear. Jones also addressed some of the findings of the other Navy investigation in his closing remarks, saying the prosecution did not dispute that the ship was lost to firefighting failures, but he said the fire started as a sucker punch from behind that the Navy could not have prevented. In the 9 days court-martial, the Navy had alleged that Mays was a disgruntled sailor who had gone down to the lower 5 with a bucket of flammable liquid, set the fire, and then snuck out a hatch, changed his clothes, and slipped back among the sailors on duty. Mace was 6'19" at the time of the fire, assigned to menial jobs such as mopping and painting. He had previously dropped out of SEAL training and had told fellow sailors that the Special Warfare Program was where he thought he belonged. Being on a ship he disliked, the prosecution said, was his motive. Investigators found a blue big lighter in May's possession and have pointed to it as the possible way the fire was started. Torres was dismissive, saying that apparently just having a lighter makes you an arsonist. The trial largely centered on two competing witnesses and arguments over whether a crime had even committed. Fire investigators with the Bureau of Alcohol, Tobacco, Firearms and Explosives ruled a blaze an arson that was started by someone putting an open flame on large cardboard boxes. But defense experts dispute that conclusion, saying that there were two other possible causes ATF investigators missed and that undetermined was the only reasonable conclusion. The defense's experts testified lithium batteries and arcing from the engine fire on forklift could not be ruled out as causes of the fire. Phil Fouts, the fire investigator who testified on behalf of the defense, said he could not with any scientific certainty say whether the batteries, the forklift, or arson was more likely the cause of the fire. An ATF electrical engineer testified that he did not take any picture or notes about the batteries during his examination of the scene. Even though the batteries were found in an area that the agency identified as the origin of the fire, the batteries were then stored in a Home Depot bucket by ATF investigator. The engineer also did not photograph the forklift. The engineer testified that upon further inspection and testing of both the batteries and the wire, he did not think either caused the fire. So thank you for watching and don't forget to like, comment and subscribe.